Welcome to the 5-Minute Legal Master Series, where expert attorneys help you master important legal topics. Today, board-certified creditors' rights attorney Nicholas D. Krawec discusses credit agreements.
Welcome. Today I want to talk to you a little bit about credit agreements. You know, in the euphoria of getting a new customer, not many creditors, especially their sales departments, want to think about their customer becoming a debtor somewhere down the line. However, when a creditor extends credit to that new customer, he is essentially lending his company's money, and there is a risk that the creditor may not get paid by this customer. Therefore, at the outset of the business relationship with a new customer, that is precisely the time to be proactive, to anticipate what rights and remedies you as the credit grantor will want and need to have at your disposal if and when the new customer becomes a non-compliant debtor. You've got to prepare for collection from day one, and nobody likes to think about that with a new customer, but the creditor needs to create an environment where the customer is made clearly aware that the creditor expects timely payment. This starts with the credit agreement. The credit agreement must clearly set forth the payment terms and conditions. If the new customer's creditworthiness warrants it, the creditor should require other creditor enhancements, which we'll talk about in a few moments. The credit agreement should identify, obviously, the legal form of the customer. Is it a corporation or a proprietorship? This will obviously identify who is responsible for payment. Creditors should periodically review the account and watch for possible changes in the legal form of the customer during the course of dealings. For example, has the business form changed from a proprietorship or a partnership to a corporation or a limited liability company? The credit agreement should also identify who at the customer is authorized to make purchases or incur charges on the account. I recommend adding a provision that puts the responsibility on the customer to notify the creditor of any such changes in that responsibility. Next, set forth the credit and payment terms. What is the credit limit? How much credit are you willing to extend to this customer? Closely monitor the account balance to ensure it does not exceed the level of credit risk that you as the creditor determined to undertake. Not every customer has the same credit history, so not every customer should get the same credit terms. And be clear about when payment is due. Encourage timely payment by offering discounts for early payment. And identify what the consequences are of default. You can reserve the right to unilaterally change the credit terms or even cut off credit if the account falls into arrears. You can change the credit terms to COD or cash in advance until the arrearage is cured, and then you can go back to continued payment according to the original terms. And of course, make clear the legal consequences of default, obviously a lawsuit. The next question to ask yourself is, what are the interest or finance charge terms? After all, the debtor who doesn't pay you is using your company's money. In the absence of an agreement with regard to interest, the creditor is generally limited to an interest rate set by statute, which in Pennsylvania is 6% per annum. For interest rates or service charges in excess of the statutory rate, a contractual interest term is required. And you can only recover your collection costs and attorney's fees when you sue a debtor if it's part of the contractual provision or there's a statutory authorization for attorney's fees. So you want to put the attorney's fees provision in your credit agreement and make the debtor responsible for your attorney's fees if you have to proceed with suit. If the credit applicant is borderline creditworthy, consider these creditor enhancements that I mentioned earlier. A personal guarantee from the principal of the corporate debtor or the principals of the corporate debtor. Maybe include a confession of judgment clause, which will allow you to confess an immediate judgment in the event that the debtor defaults on the account. And you may seek a security agreement where the debtor grants the creditor a security interest in his assets, and the lien of that security interest will encumber the debtor's assets once that lien is perfected by the filing of a UCC-1. There's a lot to go into a credit agreement. For excellent information about a responsible and disciplined credit policy, of which a well-drafted credit agreement is an integral part, I would encourage you to visit the website www.getpaidsystem.com to learn more about my colleague Bob Bernstein's Get Paid system and his book, Get Paid, A Guide to Getting Paid Faster and What to Do If You Don't. Thank you for listening.
This has been another installment of the 5-Minute Legal Master series, where expert attorneys help you master important legal topics. For more information on this and other topics, please visit 5minutelegalmaster.com.